All rise for Honorable Judge Undermine. Docket number 666-6666. You may now sit down. We have for the prosecution, Robert Sand, and for the defense, Michael Sleazeball. Good afternoon, gentlemen. Are there any motions you'd like to present before the court today?
Your Honor, I'd like to make a motion.
Okay.
I'd like to motion for a short recess because it's come to my attention that my zipper broke.
Recess?
Your Honor, I object to this motion. The prosecution is merely employing a delay tactic because they have no case. My client is not guilty. The prosecution had sufficient amount of time to correct his pants.
Motion denied. I can't wait all day. Present your case, prosecution. Are there any other motions before the court today?
I have a motion, Your Honor. At this time, I'd like this court to dismiss this case and dismiss my client of all charges. The prosecution's evidence is completely circumstantial. There are millions of gun owners in Vermont, and there is complete question and doubt as to who fired the gun, how many shots there were. All the evidence that the prosecution has is completely circumstantial. At this time, I would like to request you to dismiss my client of all charges.
No, that motion is denied.
Gentlemen, are you prepared to present your case? Prosecution Sand?
Your Honor, this is a case of first-degree murder, plain and simple. It was intentional and it was premeditated. When Matthew came back into the house, entered the bedroom, grabbed the revolver, turned back around, and met Carl at the front door, he had enough time to think about what he was doing and premeditate that he did intend to kill Carl. When he walked into the bedroom, he didn't say, "Oh no, Carl's coming after me." He said, "I'm going to kill him." This man deserves to be behind bars with a first-degree murder charge. Furthermore, I have 12 more reasons why Matthew deserves to be behind bars. Your Honor, I rest my case.
Thank you, Mr. Sand.
Your Honor, I object. Since when is it a crime for a man to indulge on Sierra Nevada?
Sit down, sleazebag, or I'll put you in contempt.
Your Honor, my client is not guilty.
Sit back down, counselor. I haven't asked you to present your case yet. Okay, Mr. Sleazebag. You may now present your evidence to the court.
Thank you, Your Honor. Your Honor, last time I checked, this was America. When is it a crime for a man to indulge in alcohol? I mean, the prosecution's evidence should be barred from this courtroom. Should be barred. Now, it was Carl's birthday. They were merely celebrating, okay? They were out, they were having a good time, and things got out of hand. We don't even know what happened. For all we know, Carl could have shot himself. The only witness to the crime is dead. And the wife, Your Honor, she doesn't even know what happened. She doesn't know if it was 1 shot, 2 shots, 3 shots, 4 shots, 5 shots. Nobody knows. Your Honor, the next thing I'd like to point out to this court is from the phone conversation that we had with the wife and the police dispatcher. I quote, Matthew said, "How did that happen?" Now, he's basically saying, how did this man die? He doesn't know. Your Honor, there are millions of guns in Vermont, okay? Isn't it entirely possible for some man with a large rifle to shoot a gun from the distance, penetrating in the same location where the bullets were, the Jeep and everything, and killing Carl? Is it entirely possible? Yes, it is. For all we know, a man shot a gun from the woods.
Saying someone from outside his house shot him in the head?
Well, Your Honor, we don't really know what happened, Your Honor. There are bullet fragments on the piece of wood and in the Jeep. For all we know, someone could have shot a bullet from the distance and it ricocheted and hit Carl. We don't know. I mean, Stephen himself said, Your Honor, how did that happen? The wife says, I don't know what happened. She doesn't even know how many shots there were.
We do have those darn liberal gun laws in this state, don't we?
Well, Your Honor, that's my point exactly. We don't know what exactly happened. There are so many guns out there, and so many people, being reckless with their guns, we don't know. Your Honor, the next thing I'd like to point out was that there were 4 live rounds found near the fire pit. 2 shell casings found inside the house. Now, is it entirely possible that somebody took 2 shots from inside the house, leaving the shell casings on the floor, then decided to be a good person and refill the gun with 2 more bullets, filling it back up? That's entirely possible. We don't know who that might have happened at an earlier date. So those 2 shell casings cannot reasonably point to the fact that there were 2 shots fired, because first of all, we don't even know how many shots were fired. So, concluding.
Thank God you're concluding.
Well, Your Honor, this is a very important case to me, and my client is not guilty, so I think it's only fair that I present all the evidence to this honorable court. Now, Your Honor, when the police arrived on scene, my client was very, very helpful, and he was considerate, and he did not create any problems. He was cooperating with the police in a very orderly fashion, and this is not the type of behavior that's indicative of a criminal, of a person guilty of murder. Your Honor, I believe my client is not guilty, and all of the evidence points to the fact that he should be acquitted of all
Was
charges.
he smoking weed?
No, Your Honor, I don't believe he was.
You know, because when you smoke weed, you're really cooperative.
Well, Your Honor, my client was very cooperative, so that is entirely possible.
Your Honor, I object to literally everything he just said.
What?
Zipper up, Mr. Sand. Motion denied.
Jury, this is a case of murder, plain and simple. Cold-blooded, calculated, premeditated, and intentional. Matthew Stevens knew exactly what he was doing when he walked into that bedroom and grabbed that revolver. But Carl had no idea that that day, on his birthday, he was going to lose his life. I hope that the jury finds in their heart that yes, maybe this man does have remorse for killing his friend, but he should be punished to the full extent of the law for taking that life.
Okay, Mr. Sleazeball. You can now present your closing argument.
Ladies and gentlemen of the jury, we don't know what happened that night. There are millions of guns in Vermont, and well, we don't know if he was shot by a stray bullet. We don't know if he was shot by a late night deer hunter. We don't know. But if you happen to find that my client was responsible for the murder, which he is not, he did so with an excuse. And I say excuse because you should reduce the crime to not guilty. Now, they were friends, the deceased and my client, they were friends, but they were drinking that night. If you find that my client was responsible for the murder, he was excused because he did so in self-defense. Carl had a history of aggressive behavior while drinking, and my client was in reasonable fear for his life. I ask you, when you go into that room and you weigh my client's life in your hands, you think about all of the evidence that I have presented you and find him not guilty.
Your Honor, may I rebut?
Sure, Prosecutor Sand.
Ladies and gentlemen of the jury, before you deliberate, do not be convinced by this talk of excuse. Matthew knew exactly what he was going to do, and he intended to kill Carl.
Not guilty.